Two adversaries in the Michelle TROCONIS trial shared their perspectives on the case during presentations and interviews for the news writing and reporting class spring 2024. University of New Haven faculty member Richard Colangelo, a former Stamford state's attorney and chief state's attorney, and defense attorney John Schoenhorn appeared separately. Both guests dropped a few newsworthy items. Highlights include Colangelo said his taped statement about the convicted conspirator in the killing of Jennifer Dulos, allegedly, quote, knowing nothing, unquote, actually referred to her not knowing where the body was buried. Schoenhorn challenged that assertion, saying the context of Colangelo's remarks during state police questioning of TROCONIS was not related to the whereabouts of Jennifer Dulos' body. Colangelo also stated his theory that Jennifer Dulos was still alive when taken from her New Canaan home. Schoenhorn offered a wide-ranging preview of potential appeals to be following TROCONIS' sentencing scheduled for May 31. The case was based primarily on circumstantial evidence and voluntary statements given by TROCONIS. Schoenhorn has stated he would not have allowed TROCONIS to make voluntary statements, which was permitted by her former counsel, Andrew Bowman. Schoenhorn characterized Bowman as, quote, sitting there more or less like a potted plant while the police grill Ms. TROCONIS for hour upon hour upon hour, unquote. It came to me, I need to reemphasize that anything our guest, Mr. Colangelo or Rich, or however he wants to be addressed, anything he says is big news because he's an authority on one of the most widely viewed trials in recent Connecticut history, the TROCONIS trial. And it, I guess, was quite a few years ago. We had a murder of a family in Cheshire, and that was a really big trial. But more to our point today, Rich is going to offer his analysis of the TROCONIS trial. And he's got some major stuff to talk about, including how he was quoted in the defense final plea to the jury and the overall context for that, which is something I hadn't heard before. So that'll be big news. I'd say other big elements, just to remind ourselves what we went over, the circumstantial nature of some elements of the case, including the murder conspiracy. Like TROCONIS was in the car with him when he dumped evidence, but what did she know or not know about the murder for which there's no body having been recovered? So I won't go on anymore. I just want to say thank you so much, Rich Colangelo, for visiting with us and sharing your experience and your insights, and then taking questions from our crew. So I'm handing off.
Thank you, Andy. Good afternoon, everybody. As Andy said, my name is Rich Colangelo. I am currently a professor in the criminal justice program at the University of New Haven, primarily teaching in the investigations master's program. Most of the classes I teach are in the digital forensic investigation program, or master's for the criminal justice program. I've got classes from digital forensics and prosecution to computer crime, networking, e-discovery. And this semester I'm actually teaching the capstone class, which people have to take to graduate from the program. I want to kind of go at this a little differently, and I really am here to answer your questions, so I'll jump into those in about 2 seconds. But Uh, in looking at the TROCONIS case, I don't think you can get to it without the Doulos case, and that's really what started everything, right? I mean, Jennifer Doulos went missing in May, May 24th, sorry, and we kind of were off and running from there. The New Canaan police called me that night when she was reported missing by her friend and the nanny for her kids. Said, hey, we got a potential missing person, but we've got a crime, an area or house. Looks like there's cleanup. I said, all right, well, let's get the major crime, unit in to kind of do the crime scene and see what they could find or figure out. And from there, we were off and running. As Andy said, I mean, it's a totally circumstantial case. Couldn't have solved it, couldn't have put it together without the digital evidence in it. And that's kind of the, I think what put the whole story together, if you will. We, seized on Fotis and Jennifer's divorce pretty quickly and saw how contentious it was, and then kind of had him or wanted him to come down to talk to the New Canaan police for a couple of days. He came down a day after he said he was originally going to come down. Walked into the New Canaan Police Department with a lawyer who was I guess his real estate lawyer or something like that, guy that didn't do any criminal work at all. Really smart detective that I worked with in the state police major crime, Western District major crime unit, was, instrumental in working there. We were, daily we were together working this case and, dealing with the different issues that were coming up. But one of the detectives asked him if he had a cell phone. He had his phone in his hand. Is that your phone? Yeah. Could I see it? Yes. Is there a password for it? Yes. Gave him the password. And then, he wanted his phone back. He said, but we're not going to cooperate. We're not leaving. You wanted me to come down. I came down, but I'm not providing any information. All right. Well, okay. See you later. Well, I could have my phone back. No, we're going to get a search warrant to search it. And once we did that and we did the extraction of the phone, we found that he traveled to Hartford in the Albany Avenue area after the day that Jennifer went missing. And that's got us to the surveillance cameras on Albany Avenue with dumping the things that were in the trash. And we have, there's a lot of different video of him dropping things. And we're lucky in a way that it was Memorial Day weekend, because the city workers in Hartford weren't really working that weekend, so the garbage piled up. Otherwise, we would have not gotten anything. It would have been gone. If it was a regular weekend, they would have picked it up. But as it is, we were able to find the blouse and the bra with the blood on it. But more, one of the biggest things we found in those bags, besides the cleanup material and that kind of thing, was the zip ties. And did you ever go to a sporting event and you buy one of those like ponchos who starts raining for like $5? They're like the clear plastic little hood kind of thing. There were two of those that were in some of the garbage bags, and they were kind of saturated in Jennifer's blood with the zip ties. And, as we put the case together, as we were talking, and we kind of took it in chunks. Once we got the Albany Avenue video and found everything that was there, did the DNA, found that it was her blood, her cleanup. I arrested both of them for, got warrants done, signed the warrants to arrest them for tampering with evidence and hindering prosecution. And that was the first arrest. After that first arrest, New Canaan, they were brought to the New Canaan Police Department. Fotis, we had really no interest in talking to him. He didn't want to talk to us, but I reached out to Andy Bowman, who was going to be Michelle TROCONIS' lawyer. And so she should talk to us because she could help herself, or basically I think I said to him, she could get on the bus or get run over by the bus. It's kind of up to her. So she ended up talking to us, providing a statement, and as soon as they were done, the state police called me and said it's like she was reading from a script. Got search warrants to search the properties up in Avon that he was staying in. Sorry, Farmington, and found those scripts that they wrote out for what they did that day, and there were things missing or left out of it. again, continuing to kind of comb through every bit of digital evidence that we can. I mean, from, New Canaan, Ring doorbells, surveillance cameras, to school bus video. I mean, in that school, so school buses have cameras that face the back so you can see the students. They also have a camera that faces the door that's always on. So as it's driving down the street, that's recording or, a video. So Jennifer's car was found on Lapham Road in New Canaan. So we looked at the bus video from Lapham Road, and first pass, there was no pickup truck parked on the side of Lapham Road. Second pass, there was that pickup truck that was parked there, and that's how we got to the pickup trucks. And then we kind of backtrack and we try to find the pickup truck leaving the property up in Farmington to driving down to New Canaan to, so and then what happened to the pickup truck? Whose pickup truck was it? And we talked to his foreman, Mr. Pavel Gemini, and found out that the truck was cleaned, detailed, and it's a 12-year-old work truck that was never cleaned since he had it. So that was the second set of charges for them, was the tampering with evidence for getting the truck detailed. Brought her in a second time. I think it was before that interview, actually, before the second arrest, she was brought in again after we found the scripts. And I told Attorney Bowman, and he's getting kind of a bad rap. And I think he would have done, or what he did was what any lawyer would have done to protect their client. I mean, he was working me pretty hard not to charge her with homicide or murder if I was going to ultimately charge a murder. And I told him the only way that I could do that, or I would be able, the only way that I would do that is if she provided us truthful information and gave us everything that she knew. In that second interview, she came in and, told us a little more. Was she as truthful as I thought she could have been? No, I don't think she was. Then she ultimately came in and talked to us a third time. And the third time he brought her in was so that I could, he was trying to convince me that she wanted to cooperate, that she potentially could become or would become a witness for us. And that's ultimately what I was working towards. And, not have me charge her with conspiracy to commit murder if I was going to charge FOTUS with it. Ultimately, it didn't work because she didn't tell us everything. She decided not to cooperate. She was ultimately charged with the conspiracy, and a week after we charged him with the murder, her with the conspiracy to commit murder, I also charged him with kidnapping because of those zip ties that I found. He used those to immobilize her, and don't know if she was dead when he took her out of New Canaan or not. My theory was that she wasn't. And that's kind of how we got to the case, I should say. Totally circumstantial, because there's no body. People thought I was crazy for charging it when we had no body, because it was going to be difficult or hard to prove. I thought that we had enough evidence. I mean, as a prosecutor, right, ethically, I shouldn't charge a case if I don't think I could prove it beyond a reasonable doubt. And I thought that we could prove these cases. And that's where we ended up. Had a leak in the state police somewhere that was very frustrating. Got a phone call from a news organization during the investigation asking about the Toyota pickup truck. I called up the state police and asked them to start an investigation on who the leak was, because that was information that no one should have. Ultimately, the leak kind of got plugged for a period of time, but they still leaked out the information that we were going to arrest FOTUS and Michelle for the murders, because they were kind of staking him up. They were outside of his house when we were going to serve the arrest warrant, which was really dangerous for the officer serving it, because who knows what he could have done, or with that information. But one bit of information that we kept really quiet was the third warrant charging the conspiracy for the murder for his attorney, his friend Kent Moweni. And then he was ultimately charged with the same charges as Michelle on the third warrant, the conspiracy to commit murder. So I want to answer your question. So that's why I'm here. So please fire away. And I'll kind of, well, I guess
Fire away, you guys.
yeah, I was going to say, I guess I could do it now. Attorney Schoenhorn made a big deal about the second interview that was done in Andy Bowman's office, where after Andy and Michelle left the room, I am heard saying that I don't think she knows, but I think she'd be great. And I was talking to the sergeant that is in charge of the unit that I work, hand in hand with through this whole investigation, Ken Matreska. And one of the things that we wanted to do at that interview was find out where Jennifer was. So when I said that I don't think she knows, I don't think she knows where the body is, because that's what we were pressing. That's what we were trying to find out. And she was talking about how she would take us through the woods, and we could go behind the house. She'll show us where he went, those type of things. And I said I think she'd be great, or I think she's great. That is again to the fact that I wanted her to, agree to cooperate and get a cooperation agreement with her, strike a deal with her so she could testify against Fotis. So
Let me jump in quickly on this one point, because this is the first I've ever heard of Rich or anybody else speaking to that context for what was used in the defense plea to the jury, that Richard said something like she doesn't know anything. And he's telling us, which I think is big news, his context for making that statement, that you said she didn't know where the body was, but you guys were hoping she would help you locate the body.
Well, we went into it trying to find out what she knew, and as far as where the body was, where Jennifer might be, absolutely. And ultimately, I wanted to get her to be a witness, and that's why Attorney Bowman kept bringing her in and letting her talk to us. Was he was hoping that the same thing would happen. One, that I wouldn't charge her with murder, and two, that I would give her a deal to testify against Fotis.
Thank you. So you guys jump in. Don't be bashful.
Okay, so I'll start, because part of my I'm trying to think, sorry. Part of my story was to kind of just like follow this case from, I think, either the very beginning or around like week 2.
Yep.
And I know watching it, one of Shoehorn's, what really struck me and like caught my eye was how Shoehorn said that she didn't really understand English, and how Spanish was her main language, and how her parents grew up speaking Spanish, how she's, I believe, Venezuelan or not from here. And so my question is, how well did he portray this like thought to the jury and all the interviews that were presented to say like, maybe she needs a translator, or maybe there's like a language barrier between the police and what she's trying to understand?
Every time we spoke to her, she never indicated that she had a problem understanding or speaking English. Every time, she never indicated that she didn't understand something. This is something that he brought up when he first started representing her. Right after she got charged with the homicide. And I'm not going to remember when, January, I guess, of 2020 was when he started representing her. So did he portray it? Yeah, but I don't think the jury bought it, right? I mean, and if you look at everything that was presented, it didn't seem, I guess let me ask you, did it seem to you that she didn't understand what the police were saying or asking her?
No.
Right. I mean, and that's the thing, right? I mean, and now here's a woman, right, that, does that alibi script. And the day that, Jennifer went missing, she was up in Farmington. and she, dropped her daughter off. She talked about how she had breakfast with Fotis. They showered together. She dropped her daughter off. She had to drop off handbags to a friend of hers. She went to Stop and Shop and took a picture of that stupid robot that bothers you in Stop and Shop that cruises around. So she got a picture. So she's trying to build her alibi, right? That she was nowhere near New Canaan. She also was the person that answered his phone. And then the one thing that we looked at from the digital evidence perspective was, Fotis's cell phone, and his pattern of life with his cell phone was that, he was not one to not, he get a text message, he'd respond right away. And I think the prosecutors did a really good job portraying how he got these text messages while he was killing his wife or making her disappear, to, not answering them and then kind of answering them after he got back to Farmington. But, the day before she went missing, Fotis set up a call with his friend to call him at 8:30 his time, which is I think 3:30 in Greece. So he called, and she answered the phone to kind of set up his alibi.
Any follow-up, Gina?
Not with that one. Thank you for answering it.
What else you got?
My next one would be, did Troconis and like Jennifer ever meet prior to, the three of them? Because I know Fotis and Jennifer's like relationship was very rocky and the divorce was very rocky. And there have been like some articles through the testimony of how, she said she didn't really like her, how she said she might kill her. And, I feel like that was a really big, not break, but a big turning point. Sure. Because, if they haven't met before, or if they have, like, what was that type of interaction?
Oh, I think she met her or found out about her when I think she knew of her. And then Fotis actually said that, look, I want to move her in here, her and her daughter into the house, and, we'll all live together. And that's really what sent Jennifer moving to New Canaan once he wanted to move her in. Looking at the text messages between Fotis and Michelle, she was very jealous type person, very kind of, I don't want to say controlling, but almost controlling type person. A lot was made of the May 22nd visit when he went to New Canaan and saw his kids, and how amicable it was and how, friendly it was, kind of thing. Well, if you were to look at the text messages that Michelle was sending him while he was down there with his kids, it was F this, F that, you're not answering me, I hope you die, all those type of things to Fotis. Jennifer, at one point in time, hired a private investigator to follow Michelle around. So she actually filed an application for a restraining order against Jennifer that was never granted. So they knew of each other. I know that Michelle didn't like Jennifer. I never got a sense of. I guess Jennifer didn't like her either, right? She broke up her marriage, but those comments were true.
Okay. Yeah, because watching the case, it seemed like Troconis was very, I don't want to say standoffish, but she didn't seem like she had any like compassion, I guess, towards Jennifer in any way.
Woman, right? She's a hard. Just looking at her, she's a hard woman, right? That comes across that way.
Yeah, no. So it was very like strange because, if you're on trial for a conspiracy to murder, you would think that you would show a bit compassion, you would show a bit, empathy towards not just Jennifer, but the family. And it just didn't seem like that anyway from her throughout just watching her. And yeah, I don't think I have any other.
Well, you get to know the state, right?
Yeah.
Okay. Somebody jump in, please.
Okay, my question has to do with the nanny that was watching the children. I remember reading an article saying that the nanny knew instantly when Jennifer Doulos didn't answer her phone, like her heart just sank because there was never a time that she didn't answer her. So I was wondering if there was like contact between the nanny and the husband after Doulos went missing that like kind of made him like go into the spotlight, made him look suspicious. Like, did she come forward with anything?
No, Lauren didn't give us really, well, nothing about, contact with Fotis after Jennifer went missing. Um, she was very helpful in talking about what the garage looked like, and what it looked like after his cleanup, right? She put out, a whole package of, paper, like bounty paper towels, and there was like one roll left. So where did the other 12 or 11 go? There were, white outdoor pillows that were not on those shelves in the garage that you kind of saw. And there's video of a guy in Hartford pulling out a white pillow out of a garbage bag from a garbage can that looks with dark spots on it that looks like it's blood, but we never recovered the pillow, but we have video of it at least. There's so nothing really about contact. Well, I shouldn't say that. Fotis reached out to try and set up visitation with the kids, after Jennifer went missing, wanting to get them. And I don't remember if that was through Jennifer's mom or the nanny. I'm not sure, but there was that contact that was kind of struck us as kind of strange, right? Because he was focusing on not finding the mother of his children, but seeing his children with the supervised visitation.
And then my other question had to do with like the jury. I know that there was like years of buildup of like insight coming from when Doulos went missing and then finding a bunch of evidence. And then I found that there was over 200 exhibits of evidence, and then with all the testimonies and the 6 charges, I was just wondering like how the jury went about like starting to deliberate with one another and coming to an ultimate decision.
That's kind of like the thing as a prosecutor you always want to know, right? What did the jurors think? How did they go about getting to where they got? But what I did as a prosecutor and what I kind of taught young prosecutors is that what we do when we present the case isn't really rocket science, right? At the end of a case, once we're done presenting it, the judge does their jury instructions, and in the jury instructions they lay out what the elements of each crime that the prosecutor charged, what are the elements and what do they have to prove beyond a reasonable doubt. So I always work backwards, right? I get the judge's charge. All right, I'm going to charge murder or conspiracy to commit murder. These are the elements I have to prove. What's the evidence that's going to go to those elements? And that's really what I think Michelle did really well in her initial closing argument, and then Sean kind of did well in his rebuttal closing argument in kind of tying everything together. Right? I mean, it is a circumstantial case, so there's no direct evidence of her being involved that was presented in this case.
Thank you.
You're welcome.
I have sort of a follow-up question to that.
Sure.
So, because the case was almost all circumstantial, did the prosecution ever fear that it would just crumble out of like, not out of nowhere, but it would crumble altogether?
I can't speak for them. I could tell you that I when we made the arrests, I didn't think it was going to crumble at all. Right. That wasn't a thought of mine when they started the trial, and I knew what they had as far as evidence and the kind of the roadmap of our investigation. Did I think that they could prove it? Absolutely. I mean, it becomes ultimately a question of what's the jury going to do. I mean, to Michaela's question, right? Jurors, right? They're going to go back. They're going to get the evidence. They're going to get the jury charge. They're going to get the information. and then the judge tells them, all right, select a foreperson, and they select a foreperson, and they'll, usually, if you think about it, how would you do it if you go about it if you're in that group or jury? And they, okay, let's take a vote, right? Who thinks she's guilty, or what charges do we agree upon? What charges don't we agree upon? What evidence do we want to look at again? And kind of get a sense of where everybody's coming from, and then just start discussing it. So that's kind of what I think they did in that room. I never brought a case or did a trial that I thought I was going to lose. I've lost cases I thought I was going to win, but I've never brought one that I thought I was going to lose.
Jump in anytime, but I'll ask a question now regarding the circumstantial nature and the prosecutor's rebuttal at the very end, which anecdotally won a lot of high praise for its effectiveness by news people and others I spoke with. But it seemed to me that prosecutor, all his material was based on the witness interviews, where he said, are there these 30 coincidences that he basically ripped her to shreds. So if he hadn't had that to work with, wouldn't have been a much bigger challenge to get a conviction?
It's a different case without her giving conflicting testimony. But even without what she said, let's look at what she did. And, what we have video of her doing, right? We have video of her with him when the bloody clothes and cleanup materials being dropped in Hartford. We have and there wasn't a lot made of it, but if you were to look at the Starbucks video after they dropped everything off at Albany Avenue, she is visibly worried or nervous. I mean, she's wringing her hands when she's talking to Fotis, and there's no audio in it, but he's doing this, like, calm down, I have it, kind of like motions. Then we go to, her taking him to get the truck cleaned. And then the day that she, that Jennifer went missing, traveling back and forth between the two houses in Farmington, and the smoke coming out of the fireplace, something burning. The only person who went back and forth was, Michelle. And then, so there's a lot there that she was involved with that could have also, convicted her. Kent Moeni was there in the office when she answered the phone, so he could have testified about her answering the phone. He provided us a statement that isn't out there at all, but he made some comments about some comments that she made with regard to Jennifer being missing.
Well, I think that all addresses the hindrance of prosecution or destruction of evidence. But what was the compelling evidence of conspiracy to commit murder?
Well, the relationship between the two of them, him not having any funds or money, trying to, if you looked at his finances, and we did, and he was more upset. I heard from his lawyer that he was more upset with me putting his financial information into the murder warrant than getting arrested for the murder of his wife. So just the relationship between the two of them, the cover up, what they did to kind of her involvement, answering the phone, kind of setting up his alibi.
Well, I thought as a human being watching her dump the garbage with him, you have to wonder, whether he does that every week with his construction garbage, or was this normal? Well, what's the burden on the prosecution to show that well, I guess they showed to the jury that her story didn't add up. How could she not have known? But did they prove that she did know?
Well, with the jury finding her guilty, the jury found that she agreed with him. What's conspiracy, right? It's an agreement to an act to further that conspiracy. And in this case, the conspiracy was to murder. So they have to agree to kind of kill Jennifer. And what's the act in furtherance of that? Photos going down. It doesn't have to be an act by Michelle. It's an act by another co-conspirator that she knows about or doesn't know about. So, it's kind of hard. Your question is, how do you? The fact that the jury found her guilty is shows the prosecutor proved it beyond a reasonable doubt. What can happen in an appeal? Could an appellate court turn around and say that there was insufficient evidence to show that she conspired to murder Jennifer? Theoretically. And if an appellate court was to say there was insufficient evidence, then they would turn around and basically that means that the conviction's void. It's kind of, so that's I've had that happen in cases before. So
there's no way this story's over, right?
No, I mean the appeals are going to be part of the case, right?
Yeah, in any big case, right?
Yeah,
where there's money to pay lawyers.
That's right. That's the big thing, right? Is being able to afford it.
Okay, you guys, anybody else going to jump in with a question for our guest about this case or his experiences as a prosecutor?
I just have a quick or like a small question. Are you guys like still searching for Jennifer's body like to this day?
It's not as active as we were when the case was new, if you will. But yeah, they're never going to stop looking. They if they get a lead or they get a tip, they're following up on it. One of the things that we did before the house in Farmington sold, the one on Mountain Spring sold. We got ground penetrating radar and ran it all through the yard, and why not? Let's try. Got approval from the bank, and we did it. Every location that his phone went, we kind of did that same type of searching. Moeni, his lawyer friend, big part of him being charged was the fact that he, had that or was instrumental in establishing the hunt club, where two hunters came across what they described as a grave. When we went there, it was filled in, but they re-excavated it, and it was dug similar to a grave. And our working theory is that hole was dug at the hunt club for Moeni's wife. And if you look at her statements to us, she talked about how before Jennifer went missing, a week before, Fotis wanted he wanted to try and be a mediator for Kent and his wife, and wanted her to come over for dinner. And she swears that if she showed up, she would have went missing and would have been buried in that hole. So the working theory is that he dug another hole, or there was another hole dug somewhere that's where Jennifer is. If I had to guess, it's in that property in Farmington somewhere. He had those two lots back to back, and then it backed up to the water company property. So there's acres and acres and acres of property there.
Did I hear this right? Fotis was going to be a marriage counselor?
Fotis was going to be a mediator, yeah, for Moeni and his wife. Absolutely right.
Okay. All right. All right. The rest of you guys,
Any other
anything?
questions?
I feel like my question is kind of more of like a what if thing.
Sure.
But I feel like the public's like a majority of the public's opinion on the verdict was somehow getting justice for Jennifer Dulos's death, even though the murderer's dead as well. Do you think that Michelle's outcome would have been different if Fotis never took his own life?
Well, I mean, I think if Fotis didn't kill himself, I would have tried him. And in looking at the evidence, you know, the exact same case would have been presented against Fotis as they presented against Michelle, you know, with some other added information. I mean, you know, we would have I would have went more into the bike and the fact that, you know, the bike was missing from his house in Farmington, and it was a bike that was similar to the bike of the guy in the video, and he asked his foreman to fix the bike a couple of weeks prior, and there's pictures of him on the bike from when he was in college, so it's a bike he had for a long time. So why would he get rid of it if, you know, it meant so much to him if he didn't use it? And one of the pieces of tape that was found in the garbage bags had a sticker from the bike on it, and then that was kind of so some more evidence tying him to the bike kind of thing. But, you know, short of that, I mean, it was pretty much the same case against Fotis. And, you know, I don't know. What do you guys think? You think he would have been convicted? Does anybody have any doubt that Fotis Dulos, you know, killed his wife? No? Right. Yeah. So that's.
Well, I'm on the show me. I wish I had been able to watch the entire trial, you know?
Yeah.
Otherwise, and even then, you don't even, you know, you don't have the complete picture, but, you know, it's hard to say without having a grasp of
Right.
case, you know.
So that's, you know, do I think the case would have been different against her? I think if he was convicted, you know, she might have come around and wanted a deal, which she probably could have had after he was convicted. You know, when she got John Schoenhorn in as a lawyer, he, you know, and Fotis killed himself. You know, what are you going to do with her case now? You know, he's dead. You're going to drop it? And I basically told him, I said, look, you could have went one of two ways when she got a new lawyer. The new lawyer could have come in and said, hey, here's what she didn't tell you, and she wants to be truthful. Or they could have come in and fought like you're fighting, John. So she wants a trial, she'll have a trial. And that's what he ended up with.
Well, is there a sentencing date?
May 31st.
So I think we can proceed. Thank you, John. You're up.
All right. Well, before I do that, let me just tell you a little bit about myself, because Andy started to say something about me before most of you logged in. So I'll just say this. You know, my practice is in Hartford. I do almost exclusively criminal and civil rights work. That is, I sue municipalities, I sue towns. That's the civil side for police misconduct, constitutional violations. I've done a fair number of free speech cases. One that I don't know if it's discussed in your class at all, involving a high school senior who had blogged about the, see when blogs were still a thing, about the superintendent canceling a Battle of the Bands. So we went up and down to the Court of Appeals and whatnot on that case some years ago. And that's, you know, Andy was involved in that case too. So I'll just note that. As far as journalism background, I was editor of my high school newspaper. I was associate editor of my college newspaper. And when I went to law school, I went to UConn. I did work part-time covering trials still while I was in law school. And I also worked for a couple of years between college and law school. And I worked for the Waterbury Republican as a reporter covering everything, but I also enjoyed covering courts and trials, and I did that as well. I became involved in but I would say 75% of what I do is criminal law. And I became involved in the Dulos/TROCONIS case. I assume everybody in this group knows about this case. Am I correct, Andy? They all know about it.
Yeah,
right?
we've discussed it. We've watched some clips, and we've looked at a bunch of articles. So,
all right. So I got brought in after Doulos committed suicide. In other words, within a day of him trying to commit suicide. It took him 3 days to die, I guess. But in that interim, that's when I was hired to replace the prior lawyer, Andy Bowman. And I don't know if any of you saw any of the interrogation videos, but he's the lawyer with the white beard sitting there more or less like a potted plant while the police grill Ms. TROCONIS for hour upon hour upon hour. So I get involved. And the first time I go to court, if you've watched any of the video, and I assume some of you have, right? Andy, is that true? You've seen
yes,
some of the...
we've shown video in class, and they've had
All right.
links, most recently to 48 Hours with Erin Moriarty.
Right. So you all know that she denied knowing anything about the disappearance or where Jennifer was at, maybe 12 or 15 times during the course of the 8 to 9 hours. So the first time I walked in to Colangelo's office when he was the state's attorney in Stamford, and they said, we've got to work out a schedule, we got to do motions, I need discovery. And his first words out of his mouth were, "Oh, well, I thought that if you came into the case, you'd be looking to work out a negotiating a deal and telling us where Jennifer Doulos's body was." So, I couldn't tell at that point whether he was joking or not. He's got a very weird sense of humor, so I just assumed he was joking. But I guess he wasn't. But that's not how this case played out. There was, from the beginning, such an intense, I would say almost ridiculous amount of publicity. If I filed, I don't know, a motion to get a document, just to request to the court, I need a copy of such and such report, there'd be a story in the Stamford Advocate, and it would then pop up on the news media, the television stations, as not necessarily the lead story, but there'd be a story about it, and eventually within a couple of days would end up in every paper in Connecticut. So the amount of publicity was a problem from the very start. And then I start getting all the trolls on social media, who don't know anything about the case factually, just opining and saying, "Oh, tell us where, the body is, blah, blah, blah." Every time she'd go to court, they would yell, "Where's the body? Where's the body?" And it became, it reminded me of one of those old 1930s newspaper yarns that you see, black and white movies you see on Turner Classic Movies, they used to have the press thing in their hat. It just said the word press, right? These fedoras that they'd wear. But that's not what the media is like today, right? But they would be yelling things out like that. So it was very difficult from the beginning to try and change the narrative. So as you all know, the pandemic hit after I get hired, right? I get hired in January of 2020, the end of January of 2020. Everything closes down by March of 2020. And everything's closed down for the next 2-3 years. The courthouse in Stamford, I don't know if this had been mentioned, they had to close the courthouse down because several employees died. Actually, the lockup there, I guess 2 or 3 marshals died of COVID. So they decided this was a sick building. You couldn't go anywhere near the building. So they actually closed down the courthouse and moved the operations to Bridgeport, which didn't make it any better. So you still did everything remotely, and they didn't have anything set up yet. So it became months and months before you get a hearing about anything. So over the course of the next couple of years, I filed probably 20 motions. We couldn't get a hearing on any of them, other than they had Michelle on a GPS bracelet and house arrest for years, and I kept filing appeals of that. Finally, the appellate court said, you got to have a full-blown hearing, why it's justified. At that point, they took her off the bracelet. So that's what happened, right? She was no longer living in Connecticut. She was living in Colorado. Her daughter, I don't know if you guys know this, but her daughter is a junior member of the U.S. Olympic ski team. and actually competed in Korea in the Winter Youth Olympics. So that's a separate story. But she was living in Colorado, competing in Colorado, and she'd come back for hearings, or we would do them remotely, which took some getting used to. I mean, now, you know, being on Zoom, being on Teams is almost second nature now. Half the things you do are on camera rather than in person, which it's a separate issue. We couldn't do a trial that way. Let's put it that way. Eventually, we got to the point where we're going to have a trial in 2022. But there was a glitch where the prosecutor tried to get me disqualified, and that took almost 8 months to get resolved. I don't know if you know anything about that. I'll just say that there came a point where a sweatshirt had turned up that may or may not have been connected to the case. It was turned into the police and happened to have the DNA of the employee of Doulos, Pavel Gumieni. I don't know if that name rings a bell. He was the employee that testified at the trial. Either you know or don't know who he is. So they said, well, I'm a witness now because my office is the one that turned it into the police. So we had to fight that. So the trial did not actually get up to the point where we're going to go to trial till the summer of 2023. And at that point, I filed, right after Labor Day, a motion for speedy trial. So we started picking a jury in October, but the judge decided we wouldn't have the trial until January, which I thought was crazy. We'll see whether that it proves to be the undoing of the case or not is an issue for an appeal, right? You file a motion for a speedy trial. The definition, the word speedy trial means speedy trial to go together, and that's supposed to happen right away. In the meantime, this jury that we picked in early October was exposed to all the media. They were not sworn. They didn't come in, so they were exposed to media for another 3 months. And as you probably know, the media continued to be over the top on this case. We tried the case starting in January, I think on the 7th of January. I can't remember if it was the Tuesday of that, after whatever day New Year's was, it was the following Tuesday. You know, we lost half those jurors. So we had to pick more jurors, mostly because of publicity, which I knew was going to happen, but, you know, it happened anyway. There were about 40 witnesses, maybe 45 witnesses. The prosecution did not feel that they needed to tell me who the witnesses were going to be until the night before the next day. So each night after court, I had to be prepared to go over, you know, remember there were 150 names on their list. So I had to go over the list the night before in order to be prepared to do cross-examination of witnesses the next day. So the trial was about 7 weeks long. You are all aware of the verdict. She was found guilty of everything. Sentencing is scheduled for May 31st. And we're working on the sentencing package. We're gathering scores and scores of letters. There's going to be some videos from family and friends that can't come to Connecticut. And I'm probably going to be doing the appeal. The appeal gets filed after the sentencing. I have no idea what she's going to be given as a sentence, but judging from the way this played out, I'm guessing it's going to be a double-digit sentence. You know, for a woman now, 49, 50 years old, never in trouble in her life. So that's where we're at. Like I said, the appeal gets filed a week and a half, I'm sorry, 2.5 weeks after sentencing. So by mid-June, there will be a notice of appeal filed, and then we got to get all the transcripts, put together all the exhibits. They got to go up to the appellate or Supreme Court, and we'll go from there. And I'll just say this before you start asking your questions. You know, although the jury spoke, I believe that they made a mistake. I believe that that was not only because the jurors made a mistake, but there were many issues that were just wrongly decided by the judge. Prosecutors put in stuff that should never have been allowed in, It confused the jury. They were allowed in closing arguments to argue that this case is about the children, which is not only false. This case was not about the children, but it constitutes appealing to the emotions of the jury. You don't tell the jury they should be thinking about the children when they're deciding whether or not a person has been proven guilty beyond a reasonable doubt of conspiring to murder a woman. So I don't know if that's enough background. That's where we're at right now.
Background. Yeah. So, okay, you guys, fire away, please.
Okay, I'll start. One of my questions had to do with the jurors. I know that there was a case where one of the jurors had shouted out to one of the prosecutors saying, like, I don't know if it was like, I love you or something like that. Like
Exactly.
supporting
We love it. Yeah.
We love you, yeah. Does that like mess, knowing you had to bring in a new juror who didn't have like all the knowledge as the other ones, does that mess with like the timeline of the trial or any initial plans?
Well, that didn't, because that happened after the jury was sworn and we had 5 alternates. So they got rid of that juror and just moved one of the alternates in. That happened early on in the case. It was like the first week of the trial. And, and to be honest with you, that juror, when we picked him, he was one of these, obviously you weren't allowed to see the jurors on the live stream, and their names weren't mentioned. But this guy, he was like your country club kind of, guy. You could just see him, wearing green checkered pants with one of those like, caps on the golf course, maybe holding a martini in one hand and a golf club in another. So he was that kind of a guy. He was probably joking, and he thought he was being cute, but the marshals overheard it. They're the ones that reported it. And quite frankly, it just didn't look good for anybody be talking about how they, quote, love, unquote, one of the prosecutors. Now, the prosecutor that they were saying this to was not one of the 2 that tried the case. Occasionally, you might have seen this very tall, younger woman. She was like 6 foot prosecutor who was usually in the courtroom, but she was not, she was one of the ones that helped prepare the case. And it could also have been this guy was kind of being sexist and just using that as a, if he didn't call her darling or honey, right, this was his way of making that comment. And the circumstances were that these jurors were in an elevator with the marshal, and the prosecutor was going to get into the elevator, but decided not to because the jurors were in there. And so she stepped back, and that's when the juror said that. So to answer your question directly, it didn't delay anything. It just required us to have a hearing, and then that guy was, booted.
Just to follow up,
Okay.
do you think that the fact that alternate jurors were brought in, do you think that it played a part in the final verdict?
Well, yes and no. Alternate jurors are there for the whole time, so they don't get brought in. They sit there and they hear all the same evidence. And if a juror leaves or has to depart, they get randomly chosen through a box. You pull one of their names, and then they just move from alternate juror to regular juror. So does that make the difference? No. Did the delay between picking the jury in October and then having to pick new jurors in January play a role? In my opinion, absolutely. And that's going to be an issue on appeal.
Thank you.
Either follow up or a new question.
Well, I'll comment on one other thing. I understand that you had former state's attorney Colangelo speak a few weeks ago, and he suggested that during the video, when he's heard in one of the interrogation videos saying to the cops, maybe she doesn't know, maybe she doesn't know anything, or words to that effect. He claimed here that, well, he meant knowing where the body was. That wasn't either the questioning that was being made at that time or the import of that comment. So the fact that that's what he's now saying, I would suggest, you should take with a grain of salt.
Oh, okay. Well, you covered the ground on that. I'll follow up on the goofy juror. Do you think he thought he was trying to bust a move or something?
Like I said, he was a guy, he was maybe, I can't remember, he's in his maybe late 50s, early 60s, if I'm not mistaken. He was one of the trustees of one of the golf courses in Greenwich. So you can sort of imagine the kind of guy, think of a Ned Lamont type of guy who's not a politician, though, who likes to, schmooze, flirt. I don't know. I mean,
Okay, all right.
he came across as that kind of a guy. So whether he was actually trying to bust a move on that prosecutor, I don't know. I think she was a foot taller than him, but whatever.
Well, I'll have a few questions, and then I would encourage anyone and everyone else to jump in. But I believe, thus far you've cited some possible issues for appeal, including the speedy trial not happening. And then in the interim, you've got, connected to it not being a speedy trial in your view, the ongoing pretrial publicity. And then I believe you cited X number of decisions by the judge. So to the degree you might comfortably be able to elaborate on appeal issues,
Yeah.
could you do that?
Sure. Before the trial started, we had a number of evidentiary issues going from the summer last August into December, just the week before Christmas. One of the hearings we did was on pretrial publicity. I had an expert from the University of Florida who was an expert in the effect of media coverage on jurors. So they have all these studies that have been done on how they're influenced by public perception about a case and how those ideas get into the mind subconsciously and are there. And they did a number of clinical studies on this, and that it injected bias into the case unknowingly. People were not able to distinguish between what they had heard about the case or what they were told about the case ahead of time and the evidence that was actually presented. So that goes part and parcel, not only to the lack of a speedy trial, but that goes to the right to a jury as a constitutional right to an impartial jury. That also leads into another issue, which is a little more obscure for undergraduates, but I'll say it anyway. The United States Constitution not only says you're entitled to a jury trial, but it says in the location where the crime is alleged to have occurred. And remember, Michelle TROCONIS was not charged with murder. She's charged with a conspiracy. And the whole evidence claims that she was doing things in Farmington, in Avon at a car wash, and driving with Doulos on Albany Avenue in Hartford when he disposed of a garbage bag. So I'm arguing as well that she had a constitutional right to have this case heard in Hartford. So that's another issue that's a constitutional issue. In addition, in the fall, there were numerous motions to suppress evidence. The warrant for the house where they found the so-called timeline, right, that she wrote down, the warrant simply said, I'm simplifying, but it basically said, Jennifer Doulos is missing. Her husband is a suspect. So we want to search the house to see if there's anything in there that might mention the wife. Now, they left out the fact the wife used to live in that house. So of course there's going to be stuff that mentions the wife. Not to also mention that there was an ongoing divorce. And in a divorce pleading, the name of the case is wife versus husband. So the name is on all these paperwork. so I'm hearing.
I don't know what the hell that's actually.
Yeah. So I'm hearing all these. These it's the
Whatever
last
it is.
person. It's somebody who's not on your who's not muted. Gina, somebody or other, maybe, I don't know.
Oh, Gina, what are you doing?
Might be, I don't know. So let me just finish. So as a result of that, they get a warrant that simply says we want to look for anything in the house that mentions Jennifer Dulos. And I'm arguing that violates the Fourth Amendment, which requires that a warrant be specific. It has to particularize what they're looking for and why. So we had that hearing. I did not win on that, but I didn't win on basically any. They put in all the cell data. The warrant didn't have probable cause. They just said, oh, she lives with Dulos, so let's look at all her cell records, see where she's been. So there's that. Then, of course, there's the infamous interrogations with the other attorney where, she wasn't given any protection at all. They read her rights and the lawyer just let her speak. And then they were allowed to turn it around and say, oh, she told things that weren't true, used it against her. No lawyer, let me rephrase that. In my opinion, because I don't want to be accused of defaming anybody, in my opinion, no competent lawyer would ever let his or her client simply go into a police interrogation without some consideration that what they say won't be used against them. They can listen, they can use it as a developing tool for other evidence, but they can't use the words against that person. Otherwise, what's the point, right? You're going to go in, you're going to confess, let's say, to a crime or not confess. Remember, the Miranda rights are not that anything bad you say will be used against you. It says anything you say can be used against you. So if she was wrong about a time frame, they said, see, she changed it, therefore she's lying. So no, in my view, no competent lawyer would do that. So that's a separate issue as to whether or not she did not have effective assistance of counsel who basically, in my view, threw her to the wolves, and then the whole case against her is based on her own words. That's my opinion anyway.
Well, thanks for letting. Okay, I don't want to keep John any more than we have to, but I'll have a few questions.
Sure.
Regarding the conspiracy charges on destruction of evidence and the trip to Starbucks at which your client was a passenger in a vehicle driven by Dulos. What's the standard of proof for any knowledge needed to hang the conspiracy charge, or do you have to actually know what's being disposed of? How is that evaluated?
Well, that's a good question, but I'm going to have to break it down because
Sure.
It's actually two questions, right? The first question is, what do you have to know? What you have to know is that whatever is in those bags is evidence of a crime that's being disposed of. That means more, and not just any crime, it has to be proof that that that's evidence of a murder that was in that garbage bag, okay? You don't have to know what exactly is in the bag. You just have to know whatever it is, it relates to a murder. And it's being disposed of to make it unavailable to investigators. Now, in addition to knowledge, you have to also specifically agree. In other words, a conspiracy is not just knowledge, because there's actually law that says you can know, but if you don't do anything, you just sort of go along. It's called passive acquiescence. That's not a crime. So you have to agree, yes, we are going to get rid of that evidence of that specific crime. I agree that that's what we're going to do it. And even if you just sit there and don't actually physically participate, you don't even have to go with them. She didn't even have to be in the truck. She could have been back at the house. But if she agreed that that was going to happen and then Doulos committed what they call an overt act. That is, he's the one who actually dropped the garbage in the receptacle, then that's what would be a conspiracy. So it's a two-pronged issue. One is you agree to commit the specific crime, that is disposing or tampering with evidence, and two, you know specifically that that's somebody is going to take action to fulfill that agreement. That's separate, of course, from whether there was a conspiracy to commit murder. And for the life of me, I don't see any evidence, I mean, zero, that in advance that they can pin that charge on Michelle TROCONIS, although she was found guilty of that. But they found her guilty of that, in my view, based solely on the after the fact stuff. So it's kind of this, she should have known, coulda, shoulda known. And that's where I think also there's an error that's going to be a subject of an appeal, right? There's nothing.
How is that different than if I'm in a car with a bank robber?
Well, let me use that as an example. Let's say you order an Uber, okay? You get an Uber. Right before you get picked up, the Uber driver went and, I don't know, robbed the bank or robbed somebody standing at an ATM machine, grabbed the $300 out of their hand, jumped in his car, then maybe to create an alibi, or he was already en route, goes and picks you up as a customer in an Uber. Cops have the identity of the car, they pull it over, they find the cash or the bank book, whatever was stolen. You're in that vehicle. The mere presence doesn't make you an accomplice or a co-conspirator. You have to have been aware of what was being done and participated. So if you're in that Uber, you happen to see the guy go out, grab the money from somebody, get back in your car, and you go, WTF, you know, like, what did you just do? And then the cops pull you over, still you're not guilty. Again, even if you have knowledge of what's going on, you're a passive observer, you're not a participant in the crime. I don't know if that explains it and answers your question.
So I remember when we were talking to Colangelo, someone asked him about the language barrier, and he said that she never presented it as an issue. So I was just wondering what your opinion was on that.
That's a good question. Did you at any point watch the testimony of my expert from Northwestern University, Dr. Marion, who was the...
Sure, we didn't come upon that.
Okay, so I'll just tell you. So the expert was she was a linguist, a psychologist, and an expert in language communications. Her whole thing was that when a person is speaking in their non-native language, that even if they have a conversational fluency, that doesn't mean they are bilingual in the sense that they speak both languages the same. And if a person is being questioned in another language, the way apparently your brain works is you take the information in your brain, you translate it into your own language, you then translate your answer from your own language and your native language into, in this case, English, and then you speak it out. That extra taxing of the brain might result in some errors, and it might result in errors because of things like fatigue, miscommunication. So remember, she didn't confess to anything. I want to be clear. She didn't confess to any involvement in any criminal activity, but some of the things she said, she later said were inaccurate. And part of that was them telling her, this isn't true, we know for a fact something, but the cops admitted that they were lying to her on occasion just to see how she might react. So if somebody tells you what you saw didn't happen, that person wasn't wearing a green shirt, they were wearing a blue shirt, for example, or a red shirt, you start to believe that. Or the other aspect of this is when the cop said, and Colangelo said, if she doesn't tell us that Doulos was down in New Canaan, we're going to charge her with murder. I mean, that was part of the evidence. And that's, in my view, an improper interrogation. So when we get back to your question, she did in fact say at the very beginning, do you have somebody, when they started asking her questions and they're reading her rights, they said on the back, it's in Spanish. And she said, do you have a Spanish speaking officer? Because I sometimes get confused. And then there's her lawyer, again, something I would never do, waving his hand saying she doesn't need a Spanish officer. She doesn't need an interpreter. And again, in my opinion, that's not something any competent lawyer should do. And I speak Spanish, right? But I would never suggest to my client, yeah, just you speak good enough. You know,
Wow.
I don't know if that answers your question, but you know, that's one of the main points that I tried to make during the course of my closing argument. But obviously, it didn't affect the way this jury thought about the case.